Justice isn't just about the law. It's about the people who fight for it. I'm Jennifer Long, CEO of Equitas, where justice isn't a concept, it's a commitment. And this is Just Champions. This season, we're breaking down the most critical court cases shaping the fight against sexual violence, intimate partner violence, stalking, and human trafficking. Each week, we sit down with prosecutors and scholars to break down the decisions that define justice and to discuss the challenges that still remain. Because the law isn't just theory. It's the foundation of real lives, real cases, and real change. Hi, everyone. Welcome back to Just Champions. And I'm so excited to be here with you all today because, and I think I overuse this word, but really today I am here with a huge champion. Ed McCann is the first assistant of the Montgomery County DA's office in Pennsylvania. But when I met Ed, he was an assistant district attorney in Philadelphia in the homicide unit, trying a lot of the cases we're going to talk about today, but just the most violent cases you can imagine, and doing it with compassion and incredible technical skill. But Ed didn't last long in the homicide unit because he was my chief in the felony waivers unit when I was moving up as a young DA in Philadelphia. And then he became chief of the homicide unit. And then he rose to first assistant of the Philadelphia District Attorney's Office before then leaving to become the first assistant of the Montgomery County DA's office. And Ed, I've lost count of the number of cases, trials, let alone homicide cases that you've taken on, but I know you haven't. Because the one thing I know about you is that every case is not just a file or a number, it's a person. So I'm, again, really grateful that you're here to talk today about your experience. And thank you for being here.
It's always awesome to be with you, Jen.
And like I said, we're going to be talking about domestic violence, homicide cases, and focusing on abusers. These particular abusers, because they target and kill people in their lives who have chosen to love them, who trust them, and basically have become very vulnerable. And what I know from working on these cases, following people like you, working with experts, is that that's one thing they say about offenders. They create the vulnerabilities that they then use against their victims. And that happens both to prepare the crime, to do the crime. And I guess I want to start and ask how you prepare. How you prepared for these cases, how you continue to prepare, because I know you're still doing these cases now.
So I think the thing with these cases, as you know, Jen, virtually all of them have a history. There are not that many domestic violence homicides that it's a one-off and it just started the day of the incident. Very, very typically, these cases involve a pattern of prior acts of violence, intimidation, control. Obviously you're going to investigate the crime as it happened, and the detectives will do all of that. But very shortly after one of these cases happens, the next thing that really, I think, is a vital thing to do is to look into the history of the relationship. Sometimes you will find situations where there has been prior law enforcement involvement. Sometimes you'll have situations where the victim has pursued protections from abuse orders, things of that nature. Sometimes you have to look deeper, that there's no law enforcement involvement, but there are people that are close to the victim that are aware along the course of the relationship. So there's a lot of evidence that can go into that story, but that's, I think, a vital component to these cases because they're very rarely just one incident. It's going to be a series of incidents that leads up to a murder.
Yeah, I was going to ask you about it because, we're missing the most vital witness against the abuser here. That person has now been murdered. So you talked about talking to other witnesses. How do you find those witnesses? How do you start to put together the story of this victim's life? Because they've been more than just a victim, although that's where they are when they come to us as DAs.
One of the things in homicide investigation in 2025 is that people's phones are just omnipresent. People live on their phones. And there's all kinds of information that can be in a phone, both from a suspect's perspective and from a victim's perspective. the contacts that they have, the people they're communicating with, text messages, emails, web searches. All of these things can be really important in making those types of determinations. And then obviously talking to the people that were close to the victim's friends and family can be a very fruitful way of getting some information about the impact that this relationship had on the victim. Many cases that I've been involved with, either the investigation or the prosecution of a case, that's where we got a lot of the information about what was going on in the relationship.
So just by you mentioning that evidence, I'm thinking about the motions you have to get ready well, whatever you have to do to prepare to get that information,
Right.
search warrants or, getting consent from the suspect, which I know people might think doesn't happen, but you would be surprised how often it does happen. And then beyond those kind of motions, we have, I know, in domestic violence cases, and they're very difficult and hard, but the other acts motions, things that try to capture the other violence in the murderer's life and how it might relate to this. So can you talk a little bit about that?
I mean, the search warrant piece is really important, particularly for phones, as anybody that does criminal practice, either on the defense or the prosecution side, knows that the Supreme Court and state courts, including Pennsylvania's Supreme Court, has cut back in terms of access to phones. That they really equate phones in some respects to almost to the level of a residence in terms of the privacy interests. So you really have to write warrants in a way that you are closely tailoring what you're seeking. A lot of times, what we do is we narrow the scope of the date range so that we're not asking for information that just is through the phone. It has to be, you can limit your access to certain aspects of what you really have probable cause to get. You have to be creative in terms of the way you write them for certain pieces of information that are in the phone. Unless you have some evidence that there could be photographs or something of that nature in the phone when you write the warrant, you're really risking suppression issues if you start rummaging through the phone and looking at all aspects of the phone. You really have to write the warrant to show some probable cause for each piece of information that you're looking for, and you should tailor it. We usually typically go back like maybe only like 30 days the first time. And then if we get additional information through the first search, then maybe it will give us probable cause to go back further. Also, you could get information from witnesses that could be helpful in putting in a search warrant for a phone to get access to information. For example, like maybe a victim sent a photograph to somebody that the defendant took of her. I mean, things of that nature. That would help you get more access to that information. So phones are really, really important to every homicide investigation, certainly domestic violence homicide investigations, but you have to be careful in terms of the scope of what you're searching and avoiding what the courts have deemed rummaging through the phone without probable cause. Like I said, friends and family can be vital. Sometimes they're very forthcoming because it's something they've lived with. Frankly, the fact that their loved one was going through a really terrible relationship and a lot of fear even before they were killed, which is very typical. So that is something that we always do. We talk to the people that the victim's close with, and again, that can lead you to other people that the victim encountered. It can lead you to other incidents, but those are, I think, the two main things. Like the phone evidence, it's really transformed homicide investigation. It's really, that evidence is almost a key to almost every investigation. It can be, if the victim was being stalked by the defendant, you can get call detail records of the defendant to plot out his whereabouts prior to the murder. That can be really important evidence. So, not just what's in the phone, but the records that kind of depict where the defendant's whereabouts were. And you can get, really good records close in time, especially to the incident. The phone companies have call detail records that are more robust than if it's later down the line. So you really want to get call detail records and access to the phone as quickly as you can.
And, this is so detailed, but even thinking about the other act you talked about, I mean, I'm saying other acts because that's I'm going to say federal rule 404.
Right.
Pennsylvania has its own,
Yep.
every state basically has some version of this. And those are technical too, because as our friend Ron Eisenberg always reminds me, and others, these are the most appealed kind of motions. So I guess how likely is it that these other crimes or other bad acts, I think we call them, of the defendant are going to come in a homicide case? And how do you prepare for that too? Because I imagine you have the same concerns that something might get suppressed or overturned.
Yeah, that's a really good point. At least in Pennsylvania, the case law in domestic homicide for 404B is pretty favorable for the Commonwealth in terms of showing things like proving the defendant's malice, showing the defendant's identity, things of that nature. So the problem that has arisen is they can be relevant in terms of witnesses, but in terms of the victim's state of mind, that's really not relevant. So the victim can express during the course of, say, the last 30 days of her life where she's being stalked, she's in fear. A lot of that's not going to be able to come in. Specific instances of defendant doing something or saying something to her that people hear or that come in through, potentially phone evidence, things of that nature can come in. But the victim's expression of fear, very clearly in Pennsylvania at this point, is not really going to be deemed to be relevant evidence.
And see, this is why it's like if everyone can picture. So when Ed was not only, he wasn't even my boss yet, and we would go to Ed's office and he had this is how old we are, filing cabinet. But you may still have, I mean, things go
I
electronic.
don't.
Well, I love that filing cabinet. It was like
Yeah.
meticulously ordered cases. But so you get like, you knew when you were coming to talk to him, all right, what can I do trial wise? What can I get in? What does the law let me to get in? I know sometimes in other parts of the country, we've talked a little bit about rest just day, or in a stalking case, like is something part of the whole crime that ended up in a murder. How have you had a case like that? How would the court, how do you suspect, if the courts haven't looked at that yet, how they might look at something like that in Pennsylvania?
So I think in a situation where you're talking about like possibly stalking case where the victim is excited, upset, something like that could potentially come in. What I'm talking about is what very many times happens in a murder case where someone literally writes down, like if something happens to me, it's that person, or I'm afraid this person's going to kill me. At least in Pennsylvania, I can't speak for other states, but recent case law has very much been of the view that that evidence is not relevant because the state of mind of the victim is not a relevant consideration in proving a murder case. So could you get that type of evidence in if you have an evidence of like a confrontation between the two where people hear stuff? Absolutely. But I'm really talking about those types of communications that we very typically see in these cases where a victim is concerned about her safety, expresses it. In that realm, the courts have, at least in Pennsylvania, have been very clear that that type of evidence is not going to be deemed to be admissible.
And we're talking a lot about the legal challenges you have to prepare, and even preparing before you get into court. What about, and I know it's hard to even think about this in a case where a victim's been murdered, but you and I both know still an effective defense strategy is to blame the victim or somehow go after them. How do you prepare for something like that?
Yeah, I mean it still happens for sure. It's happened in recent cases tried in Montgomery County. I've never had a homicide case where we put on an expert of victim behavior in a homicide case, but perhaps in some situations that would be a good tactic to use depending on the circumstances. What I have seen in many of these types of cases is the defendant not necessarily denying that he killed the victim, but trying to get off with a lesser crime. For example, from murder to manslaughter, which makes a huge difference. So if someone gets convicted of first-degree murder in Pennsylvania, it's a life sentence. Third-degree murder is a sentence where the maximum is 20 to 40 years. Voluntary manslaughter, it's only 10 to 20 years. And if the person doesn't have a prior record, the state sentencing guidelines would probably call for something like 5 or 6 years.
And what's that? What do you show? What's the difference in what you have to show the mens rea, or like the intent? What is that between those two?
Murder is what everyone knows, the specific intent to kill with malice. But manslaughter, there's no malice. In manslaughter cases, and this is typically where they blame the victim, they talk about provocation. They'll talk about something that the victim did to cause them to act in the way they did. And if they prove that, if they prove the provocation, or they prove that it was mistaken belief in self-defense, meaning the victim was coming after me and I had to defend myself, and the jury doesn't believe the self-defense claim, but they could say, well, there's something to that. They could give the person a voluntary manslaughter verdict, which to me is really almost never justice in these cases, because you're going from someone getting like a significant sanction to probably single digits in jail for killing somebody. So that's a very typical way of sort of blaming the victim. I was provoked. She cheated on me. She punched me. She said something about my manhood, whatever. And that caused me to become enraged. And that's why I killed her.
And I know we're going to move on to the case we're going to talk about today, Rahimi. But before that, it's interesting because when you and I were talking about getting ready for this, we were talking about, domestic violence, homicide cases that you've handled. And the one you wrote, of the many you wrote down, is the one I remember precisely sitting in the courtroom and listening to. And this one's interesting because, again, it highlights that the people who are killed as a result of domestic violence homicide are sometimes not even the people in the relationship. And this was the case with Natisse Johnson. And I think it dovetails well because she was shot by the perpetrator, right? And pregnant.
She was. Yes. Natisse Johnson, she was 9 months pregnant. She was actually killed on her due date. And her friend was the domestic violence victim. The defendant in that case, Kareem Sampson, had a relationship with Natisse's friend that was breaking up. And he was very upset by this. And Natisse was actually someone who was a shoulder for him to cry on, and actually was friendly to him and felt like he was kind of getting a little bit of the raw deal in this relationship, for lack of a better word. But then things really escalated, and he kept on coming to Natisse to try to find out where his former girlfriend was. And the evidence at the trial suggested that the day that Natisse was killed, she told Kareem, the defendant, that her friend was a big girl and she could be with whomever she wanted to be with. And he got enraged by this, apparently, or still wanted to try to find out where his girlfriend was, drove to Natisse's house, came in the house. She was, as I said, 9 months pregnant, shot her in the back, as we argued, and I think the jury accepted. She was running away from him in a hallway, and then shot her 3 times at close range in the head, including a contact wound on her cheek where the muzzle was literally imprinted into into her cheek. So in that case, we actually did put on acts of violence that he had engaged with his girlfriend that led up to the murder, to show that the motivation as to why he did what he did.
So I think, digging deeper today when we were talking about Rahimi, it's the perfect case. It's a Supreme Court case, but as we know, these cases start in local courtrooms somewhere, and it's not a domestic violence homicide case. But given the abuse and the use of firearms by this defendant in this case, I think it's pretty likely it could have become one at some point. And I'm not sure if, 18 USC 92 G8 is it existed at the time, the federal law that prohibits abusers, if certain conditions are met, from possessing a firearm. But these are the kind of laws that try to keep victims safe. So could you give us a little summary of that case, the holding, some of the background?
Well, I thought the case was interesting because As you know, I'm really into history, so it's a heavy history case. I mean, all the justices that wrote in the case really leaned on the whole concept of originalism gets debated within this case. Although it's 8-1 ultimately in terms of the fact that the regulation was appropriate and that the fact that he was prohibited from firearms was rooted in the Constitution, that it was constitutional. It's sort of a fascinating debate in terms of there's a lot of opinions in the case. A lot of the justices wrote separately to essentially set forth their view on interpretation of the Constitution. But in essence, the court decided that a regulation that prevents a domestic violence offender from possessing a firearm is rooted in the Constitution. That at the time of the founding, there were laws in effect where people who threatened to harm others could be prohibited from possessing a firearm. And the court found that the fact that that did exist and that in this instance now, the defendant in this case was allowed to have a hearing. He had a hearing on the protection from abuse order, had an opportunity to be heard, and then that there was a judicial finding that he was a danger, was essentially very similar to the types of judicial proceedings that were available back in the 18th century. And that's why they said that this provision was constitutional.
Yeah, I even remember in the decision, they looked back at like 1200, 1300. I mean, they went back to 800 years.
You're right. I mean, most of it sort of centered on the 17th century England and 18th century, new U.S. colonies, and then the new country that we had. But they really did dive deeply into that notion, and they found, they're looking at this because the Bruin case a couple of years before that had said this is what a court needs to do when making a determination about whether a regulation concerning firearms is constitutional, whether it meets the mandates of the Second Amendment, essentially. So, I mean, they did a really deep dive into the fact that, yes, this is very similar to what happened. They really didn't go too deeply, although there was one reference to a spouse being able to bring
Yes,
forth such a claim, which I was very
I
shocked
was
by,
too.
frankly, when I read the case. But that was the only thing that was similar in terms of a domestic violence concern. But they essentially said, yes, there was a judicial procedure in place in the 18th century that said you could go to court and prevent somebody from possessing firearms because they were a danger to others.
Yeah, I thought that it was so interesting, the argument that it had to be identical, basically, versus relevant. And I know one of our staff loves that part of the decision where it says, like, we're not, what is it, putting laws in amber or decisions in
Yeah, it was
amber.
talking about Amber.
Yes,
Yeah,
like
yeah, a
basically
little Jurassic
fossilized
Park
a little,
reference. Yeah,
exactly. And I mean, again, just as a so I feel like this case too, the underlying case, is a good reminder of what victims go through, because this victim, before she went in for protection from abuse order, and there was evidence at that hearing that there was a lot of other abuse. They were in a public place. They had an argument. Rahimi became enraged. He grabbed her by the wrist. He shoved her into a car. He shoved her hard enough where her head hit the dashboard. And then when he noticed a bystander, he grabbed a gun from his car, and she took that opportunity to run away, and he shot at them. The court didn't know who he shot at, but he shot in the direction of either the bystander or the victim. And that's what happened before she came in for the protection from abuse order. After that order, this guy was very active. I mean, there were like 7 other incidents
yeah. I mean, he was involved in a bunch
with
of different
guns.
shootings, including a road rage incident, including an incident over drug trafficking. So yeah, he was a very violent, dangerous guy for sure.
Yeah. So it's like, we talk about domestic violence again, these myths that these are in-home offenders, that they don't pose a danger. They, first of all, pose a huge danger to the victim. They shared a child together. So to the child, I think the protection order also protected her family members. But to the public, I mean, we heard Ed when we were talking about Natisse Johnson, that's just a friend. And then you've got some random people on the street who are bystanding, and they're also, involved. Do you get a chance to work with appellate attorneys in your work? I mean, you're on the trial level. I know when we were in Philly, we didn't handle our own cases, but you're handling such serious cases. Could you talk a little bit about how you work with the appellate attorneys, either before, during, after your cases?
Yeah, that's a really good question. I mean, I've done a little bit of appeals work in my career, but the point you're making, we have a fairly large office, so we have our own appeals division. A lot of offices don't, depending on on what their size is. So, to your point, that do I work with them? Absolutely. During trial prep, particularly on the types of issues that you were talking about earlier, like the 404B issues. Obviously, appellate attorneys tend to be more conservative than trial attorneys. I actually started in the law division in Philadelphia, so I've always kind of been a little bit of a maybe a little bit more of a conservative trial lawyer because of that. But I think they're a really good resource for us in terms of these are the types of things that will help us when we have to defend this conviction in the appellate courts. So yeah, that is really helpful. Particularly in sort of framing the 404B evidence, because as you said earlier, that can be an issue that gets attacked if a defendant is convicted. They're always going to say, well, it's a trial within a trial, and that wasn't something that the jury needed to hear to make their determination. So we definitely spend time speaking, at least, when I try a case, and I always try a case with a partner now. I never do them by myself. Our trial team will talk to the appeals lawyers on issues like that. I think it's really important because they really know too what the trends are, like where the case law is going, what types of arguments that might be successful or unsuccessful in terms of the things that we need to concentrate on. And they could tell you, listen, you're good with those four, but maybe that fifth one is something that we'd have a really hard time standing that up. So maybe you should think about whether you really need that fifth prior act evidence. So they can be really good guides as to where we should be thinking in terms of not just getting the conviction, but making sure it's sustainable afterwards.
Yeah, and even after at the appeal, I think we were at the appeal stage, we were very lucky in Philadelphia because I feel like not only were they so smart, but they're grounded. I mean, you're all working together in an office. They're not living, in an ivory tower. They know the violence that's going on, but still, sometimes you worry, does the person handling the appeal, do they understand domestic violence? Do they understand the dynamics? I know you're there in the appeal to argue the law, and you're I don't want to say stuck with the record, but you're stuck with the record you have. There's no witnesses. How did you ever have an opportunity to make sure that they were educated? Do you think it helps if the appellate attorneys understand these cases and the dynamics?
I definitely think that. I mean, I think in really big cases, and we've had some of them here, we've had appeals lawyers sit in for part of the trial. The end result was not good, but the Cosby case is a perfect example of that in terms of the rape myths and other acts evidence. In that case, we actually had an appeals attorney who argued some of the pretrial motions and was present in court for some of that evidence. So I know that's not the same thing as domestic violence, obviously, but it's the same principle in terms of there are things about domestic violence that the public is really not, that's still not fully educated on. I mean, you still get that old "why did she stay with him" thing. I
Right.
mean,
I was just
you
thinking that.
still hear that
Yep.
all the time. Even after in 2025, you still hear it in situations where a woman has been threatened, she's been stalked, she's been abused, her family's begging her to leave the guy, and she's killed. You still hear people say, "Why didn't she
Yeah.
leave?" So yeah, I mean, I think that it's important for everyone to be educated, and certainly in a situation like that, it would be the best thing for the case would be to have the attorney that is going to argue it have a full understanding of those issues.
I mean, that's incredible. Actually, I don't think I've ever heard, that doesn't mean it's ever happened, but I've never heard of the appellate attorneys being in trial, and that's incredible. Just another piece of evidence of how innovative your office is, how thoughtful you are, how diligent you are. And I mean, I know you were never in the family violence sexual assault unit, didn't stop me from coming to you, as well as my own chiefs, but coming to you to work through cases. But I think That's a really innovative way and a way for the appellate attorneys to understand the evidence not on the record. They're stuck with a written record, but having an understanding and because there's nothing like seeing the demeanor of someone.
Yeah, I was never in family violence, but I kind of always felt like I was. I obviously, domestic violence became something really important to me when I was the chief of the homicide unit. We were fortunate enough the last part of my time there to have a deputy commissioner, Pat Fox, who was really passionate about reducing the numbers of domestic violence homicides, which had gotten really, really large in Philadelphia. One year we had like 34, and there was a lot of reforms made in the police department like early on. Like everyone knows, talks about lethality assessments now, but that wasn't really, not people weren't really talking that way even as 15 years ago, 2008, 2009. That wasn't something that was standard like it is now, thankfully. Um, so there's been a lot of progress made, but there's still a lot of people grounded in that old thinking.
Yeah, and I'm thinking about that one thing you said too about, you hear these numbers, 34 DV homicides, and you've given us, a conversation about who those people are, what they did, how they walked into this. And they're not, it's hard, you see statistics of everything. It's so clean and it's really not.
No, it's not. I mean, I think that's a great point. I mean, I've always said this about domestic violence, homicide, and I said this when we used to do the training for Equitas when we did it, a few times all throughout the country. It was great. But one of the things I always said at the beginning of that training when I'm talking to young prosecutors is, when I look back at these cases and you read the appellate decisions even about these cases, when they go through the prior events, these are really terrifying cases, because I always think about the fact that the person who's the victim in this case, it's a terrible thing, obviously, to be murdered, for the person and for the person's family. But it's worse, in my view, to be terrorized up to the time that you're murdered. So many of these cases, that aspect of terror and fear of some long standing happens, and that's a really terrible thing about these cases.
Yeah. Um, Killed by the person who's supposed to protect you.
Right.
And so, you know how I feel because I'm always saying it that the world needs more legal champions. They need more people. And I'm lucky enough to know, I mean, you're one of a kind. And other people like you who are across the country, across the world, really doing this type of work, standing up for victims. So I have 3 questions I like to ask everyone. They're rapid fire, if you're ready. What's the hardest lesson you've ever learned in the courtroom?
Well, I guess the hardest lesson is a lesson you learn early on in your career, and it can continue. And that is that the right thing doesn't always happen. That sometimes you have the facts and the law, and you know what justice should be, and it doesn't happen. That can be extremely difficult. That can shake your faith a little bit.
Yeah. How about what would you tell young Ed about about this work? Young you.
I mean, I don't have any type of regrets. I think the thing that has kind of sustained me all these years is that you have to have a life outside of it. So I would tell my younger self that it's really important to lean into your family and to your loved ones and to your friends outside of the job, and not to be all encompassed by it. This work can be very challenging to have that balance, but I would reiterate that.
Yeah. And what keeps you coming back, even though it's tough? Everything.
Yeah, I mean, I feel like it's a job where you can make a difference for people that really don't have a voice. You can give them a voice. And the other thing that really keeps me going is I'm just really lucky to have great colleagues. I know that the next generation, we're going to be in good hands. These people have the same type of commitment to this job. If anything, they'll take it to the next level. So I feel really good about that part of it as well. So I know I'm closer to the end, but I feel good about the future. I even, I still think that we have a lot of really great people that are going to continue on with this work.
Well, I couldn't have scripted that ending any better. So thank you. Thank you for everything you do. Thank you for taking time out to come and talk about the whole range of things and a Supreme Court case. Just thank you for being here.
It's always great being with you, Jen. Thank you.
This podcast discusses the violent crimes of sexual violence, domestic violence, stalking, and human trafficking. If you need support, please check the show notes for links to hotlines and agencies that can help. For more information about Equitas, please go to equitasresource.org. That's AEQUITAS resource.org, or follow us at Equitas_resource on Instagram. This series is executive produced by Jennifer Long, Equitas, and Robin Hopkins. This series is sound designed and edited by Dan Kroll. This season of Just Champions is funded by a generous grant from the U.S. Department of Justice Office on Violence Against Women, supporting efforts to improve justice in cases of sexual violence, intimate partner violence, stalking, and human trafficking. The opinions, findings, conclusions, and recommendations expressed in this podcast do not necessarily reflect the views of the Department of Justice Office on Violence Against Women.